Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. And today we're going to talk about the top 5 things to look over in your residential real estate contract. So after you sign a contract with your real estate broker, your attorney will have 5 days to propose modifications to the contract before the contract becomes official. And we have a whole post about attorney modification and that process. So if you're curious about that, you can go to learn-about-law.com to check out our post about attorney modification. We have a video and an audio and an article about that. But today we're going to talk about the things that you're actually going to go over with your attorney in the real estate contract. And there's 5 big ones that we want to make sure we hit with every client. The first is purchase price and earnest money. So there's a paragraph that lays out what the purchase price is. We want to make sure that's accurate. We want to make sure you understand any closing cost credits that are going to happen. A closing cost credit is a reduction or addition to the purchase price at closing based on certain things that happen between the contract signing and the closing. So sometimes if you find problems in the inspection report, you'll negotiate a closing cost credit to account for repairs that need to happen. We want to make sure you understand how those credits work and how they interact with the purchase price. Also, earnest money. Earnest money is a down payment by the buyer to a third-party escrow agent. It's usually one of the realtors or one of the attorneys involved. And if the buyer backs out of the deal or if the deal falls through for certain reasons, the seller gets to keep that money. If the deal goes through and closes, then that's just part of the purchase price and the seller is paid that earnest money at the end of the deal. So there's a couple different ways that a deal can fall through and the buyer doesn't have to keep their earnest money that are typical. One is if there's a mortgage contingency clause and the buyer isn't able to obtain a mortgage, then they'll probably keep their earnest money. If the property doesn't appraise out at the value of the purchase, if it's contingent on appraisal, then the buyer will keep their earnest money. And also if there's problems with the inspection report and the buyer decides to back out for that reason, and the contract's contingent on the inspection report, not an as-is contract, then the buyer might be able to keep their earnest money. But we want you, either as a buyer or seller, to understand the situations in which the contract could fail to close and who's going to be getting the earnest money in those situations so that you can meet all of your obligations and if you're the buyer, not be on the hook to have to pay this part of the down payment for the deal falling through. So, number 2 of the 5 top things you want to look out for in your real estate contract is the paragraph regarding fixtures and personal property that are included in the transaction. So in these foreign real estate contracts that realtors use, there's a list of different types of personal property that is commonly included in real estate transactions, and the realtor will go through and check boxes, checking off which pieces of personal property are included in the transaction. There's also a couple blank spaces where the realtor can write in additional pieces of personal property, and we're talking about dishwashers and fans and other things that are kind of part of the home but could be removed. And if it's not something that's listed in those the list of traditional pieces of personal property that are included, the realtor can write in additional personal property. They can also exclude certain personal property just so that the contract's not ambiguous. So if you're going to be taking all of the ceiling fans with you, the realtor might want to write that into the contract that those aren't included in the purchase price. So we'll go over the contract with you and make sure that you understand what's included and excluded as far as the fixtures and personal property, and sometimes we'll negotiate to have additional fixtures included in the purchase price. But it's important that both sides have a meeting of the minds about that and that the contract's correct in that respect. The third big thing to look out for in your real estate contract is the mortgage contingency clause. So some deals are cash deals and the buyer isn't obtaining financing and they're just responsible to bring cash to closing. But most of the time the buyer has to obtain financing in order to pay for the purchase. And most of the time the deal will be contingent on the buyer actually being able to obtain suitable financing. Now, suitable is the key word here because the mortgage contingency clause lays out the type of financing that the buyer has to be able to get, the interest rate that the buyer has to be able to get, and the amount of the purchase price for the financing that the buyer has to be able to get. So if the buyer isn't able to be able to get a VA or FHA loan, if that box is checked saying it's got to be a VA or a FHA loan, or if it's got to be an adjustable rate mortgage, and they're not able to get that type of mortgage, then they can back out of the deal and they'll usually get their earnest money returned. Similarly, if they're able to get a mortgage but it's not for the amount of the purchase price that's listed in the agreement, or if it's at an interest rate that is higher than the interest rate listed in the mortgage contingency clause, then the buyer has a way to get out of the contract. So we want to make sure both sides understand and agree to the terms that are in the mortgage contingency clause that will allow the buyer to get out if they're not able to obtain that type of mortgage. Just as importantly, in the mortgage contingency clause paragraph, there's a series of deadlines, just a couple of them, that the buyer has to meet in order to provide proof that the mortgage process is moving along and that that the seller can expect the deal to go forward. So we want the buyer to know what those deadlines are so that they and their lender meet those deadlines. If they don't meet those deadlines, then the seller can get out of the contract and usually keep the earnest money. So it's important that both sides understand what those deadlines are. Now, a lot of times the process will go a little more slowly than expected, and the buyer won't be able to meet that deadline, and if that happens, then we just want the attorneys to agree to an extension. And if the seller wants the deal to go through, the seller will agree to a written extension. But it's important to either meet the deadline to provide that proof that the process is moving forward, or to get a written extension before the deadline occurs. Because otherwise, as the buyer, you're in jeopardy of losing your earnest money and having the deal collapse. So, fourth of the top 5 things to look out for in your real estate contract is the tax proration clause. And this is probably the most complicated thing we have to talk about today. When you're buying a piece of real estate, you're usually buying it in the middle of the year, and you're going to get a tax bill at the end of the year for the entire year. The part of the year that you lived in the home and the part of the year that the seller owned the home. You as the buyer are getting the bill for the entire year. And you as the buyer are going to be ultimately responsible to pay for that entire year. But we really want the seller to pay their fair share, so that's usually accounted for in these real estate contracts. And what we do is we take the prior year's tax bill and multiply it by a certain percentage to come up with what we expect the current year's tax bill to ultimately be. So the attorneys will look at the prior year's tax bill, and the contract will provide that the estimated amount of this year's tax bill is going to be either the same as the prior year's tax bill, or 105% of the prior year's tax bill, or 110% of the prior year's tax bill. Those are the 3 common ones. And usually it's 105 or 110%. So if we're representing the buyer and you're not getting that 105 or 110% of the previous year tax bill, we might negotiate it up to that because that's standard. And we want you to be aware of that. If you understood that at the time of executing the contract and you're fine with not having the tax bill increased as far as what the seller's going to pay towards it, then that's all right. We just want to make sure you understand that the seller's going to be on hook for their share of the year, and if the tax bill goes up and you haven't accounted for that in the closing and they're not paying 105 or 110% of the previous year's tax bill, you as the buyer might be on the hook for more than your proportionate share. So once we've figured out what we expect the next year's tax bill to be, either 5% more or 10% more than the previous year's, then we calculate how many days, and we do this right before closing, how many days that the seller has owned the property in the year and what percentage of the year that was. And we have the seller pay their prorated share. Prorated means it's their percentage of the year of that 110%. So we take a look at, what's the amount of 110% of the previous year's tax bill, and if the seller has lived in the house for 70% of the year, they'll have to pay 70% of that amount to the buyer as a closing cost credit. And the buyer gets this right at closing, and they can do whatever they want. It's their money once they receive it. They can spend it all if they want. But when that end of the year tax bill rolls around, they're going to be responsible for paying for the whole thing. So this is just the seller paying the buyer in advance for their share of that end of the year tax bill. So we want to make sure that the percentage is correct. So how are you calculating what you expect it to be? And then the real work comes in at closing for the attorneys to make sure we've got the math right on that and the seller's paying the right amount. So the 5th thing to look out for in the top 5 things in your real estate contract is that there's a series of optional provisions at the end of the contract that don't apply in most situations, but sometimes they do, and if they apply, both sides will have to initial that section to indicate that that section applies to this contract. And so what are these types of optional provisions? One is that the contract is, or that the property is being sold in as-is conditions, so that when the buyer signs the contract, if they find out something about the property before or after closing, they're still bound to go through with the contract. So there's not going to be an inspection of the property. They're just taking it as it is. And sometimes when it's sold in as-is condition, you still have it contingent to an inspection. But any defects that are found after the signing of the contract, or if it's contingent on the inspection coming back, any defects that are found after that are the buyer's problem, not the seller's problem. Another optional provision is that the contract's contingent on either the buyer or the seller closing on a separate real estate transaction before this closing. So, if the seller wants to make the contract contingent on them finding another house to buy, or the buyer wants to make it contingent on them selling their own home, you can initial that provision. But we want to make sure that both sides understand and agree that the contract might fall through based on that contingency, and make sure that that's what they want. The third, and this is kind of rare, is that the seller is still allowed to list the property for sale until closing. So if they get a better offer, the seller's allowed to back out of the deal. And that happens when it's a really heavy seller's market, or the buyer really wants that particular home and the seller's got a lot of negotiating power. But there's a whole bunch of other optional provisions that can be checked off, and we want to make sure that you understand, if any of those are checked off, that it's a little bit different from a regular real estate closing. Those are the top three. So again, to kind of recap, the top 5 things to look out for in your residential real estate contract: the purchase price and earnest money, fixtures and personal property that are included in the sale, the mortgage contingency clause, the tax proration clause, and the optional provisions that might be included in the transaction. So if you want to learn more about real estate law or any other type of law we practice, which is most of them, you can go to learn-about-law.com. We have a whole bunch of videos and podcasts and articles about legal topics. I also do a podcast called seizeyourbusiness.com where I interview business owners to provide my listeners with successful strategies that they're implementing in their business. So check out seizeyourbusiness.com if you're a business wonk like me and you want to learn more about business. If you'd like to schedule a consultation with O'Flaherty Law, like I said, we handle most areas of law, and we're very good. You can call me at 630-324-6666. That's 630-324-6666. And certainly if you have any follow-up questions based on this or any other podcast or video blog, you can feel free to call me or send me an email. My contact info is on all those websites that I gave you. So thanks so much for listening.